thank you so much, Shena, for agreeing to speak with us today on joint ownership of property, which includes bank account and house. You're going to be sharing your expertise on the area and shed some light on a few questions that we may have. Welcome.
Thank you, Lestine. I trust that I will be able to assist you and the persons who listen to this program.
You will, no doubt.
Ownership of property is, of course, something that's very near and dear to the hearts of many persons. You've asked me to speak about joint ownership of property in particular because of a discussion that you and I were having recently. No, you can have joint ownership of property in various types of property. It could be real estate, for example, houses, lands, or it could be something that's not real estate, what we in law would call personal property. For example, bank accounts, or even something like a motor vehicle. You could have joint ownership of something like that as well.
Okay.
Now, for the sake of convenience, you'll find situations oftentimes where persons may add a loved one to their bank accounts, and it can be for convenience, as I said before. It could well be for a case of convenience, or it could be that you just think it prudent to not be the only person on your account.
Yes.
And you want someone else to be able to access it in the event something should happen to you or you should meet an untimely ending. You would want someone else to be able to easily access their account.
Yes.
No, so it can be useful if you have a bank account to add someone to the bank account. There are pros and cons to adding persons to your bank account. On the one hand, it can be useful, and on the other hand, it may be devastating. It could be useful because you could add someone, especially in a situation with married couples.
Yes.
You may decide to add your spouse to your bank account so that that spouse will be able to easily do transactions that you may not have the time or the convenience to do. And in that case, you may say, let me add my spouse to the bank account as well, so that he or her is able to effect transactions when I'm not able. So to that extent, it can be a convenience. If you're an elderly person as well, you may decide to add a younger family member or a close friend of the family to the bank account, because you feel that such a person would be able to go to the bank and do transactions when you might not be able to do so. However, as I said, there are cons as well. Adding someone to your bank account, as far as the bank is concerned and as far as the law is concerned, gives them an interest in that said account. And while you're alive, that interest is joint. You both have unlimited access to that bank account. But what happens is that a principle called principle of survivorship actually kicks in if you die. And if you die, then the person whose name remains on the bank account, that person then becomes the owner of all the funds in their account. I can think of a case where a gentleman, an elderly gentleman, had put a younger cousin on his bank account, and he had only done it for convenience. And during his lifetime, as often happens, she never touched the account unless he gave her permission to do so, to withdraw some monies and bring back to him.
Yes.
No, he did a will, and she would have known about his will as well. And she would have known also that he had willed that the money in that account on his death should go to his wife. He was close to this younger cousin, and so he appointed her in his will as an executor of the will as well.
Yes.
When the gentleman died, the younger cousin in question did nothing other than to go to the bank and withdraw the millions of dollars that he had in the account. And then, knowing that having done something so dastardly, even though legally so, having done that, she stepped down from the position of executorship. She decided to relinquish her responsibility as executor to the will, and instead she withdrew the money. Now, the estate, that's the family of the deceased man, had heard through the grapevine that she intended to withdraw the monies from the bank account, and they had reached out to the bank in advance and pointed out to them that there was a will, and that in the will the gentleman had left the money to his wife. The bank said there was nothing that they could do about it because the wife's name was not on the bank account. It was this younger person, and the person went down to the bank and withdrew every farthing from the account. So one should be very careful when one is putting someone's name on their bank account. To your mind, it may be for convenience, and as during your lifetime, the person may even tell you that if something should happen to you, they will make certain that the monies go to your loved ones. But you should never rely on what persons tell you while you're alive, because as an attorney, I've seen so many cases. Nothing brings out the worst in persons as deadlift. Right? It's true. So unless you want and intend for the person whose name you are adding to their account to get the monies in their account, it's not sufficient to leave a will or designating who should get the money. Unless you want the person to really inherit that money after you die, then you shouldn't add their name to their account. Or you should try to deplete it at the first opportunity that you get. When it comes on to real estate, it's similarly tricky. Many attorneys, especially when it comes on to married couples, their default advice is that the parties should put their names on the property that they're purchasing as joint tenants. But again, there are pros and there are cons, right? A married couple, if you put the names on the title to the house that you're buying or to the bit of land that you're buying in Ocherius, if you put it on as a joint tenants or tenants in common, it can make it less of a hassle when one party dies, because then it's easier for the interest in the property to then just move to the other party, and that would also have implications for transfer tax. But there are other scenarios which could play out. For instance, let us say you have a woman that's hardworking, a couple, you know, woman, husband and wife. The wife is very hardworking and she has saved hard over the years, and she's a driving force behind the husband, and maybe she even earns more than him. So when you peel it away, she's really the force behind the couple owning, let us say, 3 properties, right? And let us say, because they go to an attorney who says to them, oh, you're a married couple, so just put put the properties right as joint tenants. I'm not talking about joint tenants is in common today, because that would be a different principle. But they say to you, put it as joint tenants, and if one of you die, the interest in the property will automatically go to the other. And that appears a very reasonable suggestion, because you're in love and you say, after all, you know, I would want my wife, the husband is thinking to get it, and the wife is thinking to herself that, okay, if anything happens to me, I would want my husband to get the properties so that he can use them to the benefit of any children that we now have or may have. So let us think about a scenario, as I was saying before, for instance, where the wife has pushed and masterminded the acquisition of these 3 bits of real estate, 2 in Kingston and maybe 1 in Old Harbor, right? And then the wife, the couple have 2 children. The wife, unfortunately, dies at 45. And she leaves behind 2 children, let us say 10 and 12, right? I'm talking about a scenario that plays out all the time, where a party to a marriage, a union, dies quite suddenly at a far younger age than we would anticipate given the usual time span. So let us say the woman dies at 45 and she leaves behind 2 children, ages 10 and 12, right? The husband is of course very saddened because he has lost his wife at a young age. Maybe he's in his 40s too, so he's very saddened. And he mourns her death for 7 months.
Wow.
Right? And
That's
meets and then he meets a young damsel
in distress
who is willing to console him while he's in distress. And maybe that damsel has 2 children of her own.
Yes.
And he falls head over heels in love with her.
Yes.
Sometimes when persons are mourning, that's when they're at their most vulnerable, and you know, they will fall in love easily again. So let us say he meets this damsel 7 months after, call it a year if you want.
Yes.
And then they get married.
Yes.
You know, 6 months later they're married. So you could have a scenario where in another year and a half the man has remarried.
Yes.
After the death of his wife. And what would have happened, because the property was joint tenancy, all the properties were joint tenancy, they would have passed on the principle of survivorship straight to the husband, right? So fast forward 2 years down the road. So they have been married for 2 years now. Mr. Husband has added the new wife's name to the properties. So have you noticed what has now happened?
Yes.
This lady would have worked very hard, the original woman in the picture, wife number one, would have worked extremely hard to acquire these properties, right? With the hope in her mind that her children would ultimately benefit through the father, right? And you know, she really hopes and wishes and relies, they're both relying on each other, that in the event that something happens to me, then my spouse will take care of the kids and the properties will eventually pass on to the kids. But fast forward, as I say, 2 years after marriage, and then you know what, the other lady is now on the title, and then let us say that the husband himself dies, right? So you could find a scenario where the wife number one, her children are now like
out in the cold.
15 and 17. And who owns the property 100%? Wife number two owns the 3 properties 100%, and she has 2 children who are not the husband's children. And it would be such a sad scenario, a sad case to see that unfold. Because I know that as a woman, if I work hard, I would want to see my children ultimately benefiting. But because my husband and I did not acquire the properties in question with separate interests, which is what you would call tenancy in common.
Okay.
We acquired them as joint tenants. What has happened now is that my entire interest has been extinguished with my death and the subsequent death of my husband, and gone on to a third party who has no obligations to my children. She could then sell the properties, she could pass them on to others, and my children would have benefited in no way from all the effort and monies that I put into the original acquisition.
So it's best to do the tenancy in common versus the joint tenancy.
Attorneys need to talk to their clients and not just tell them to go the route of joint tenancy, and to find out what's in their headspace. Some clients will say to you, after you have explained the risk to them, we do not intend to have children, I'm very comfortable leaving everything to her. I know that if anything happens to me, I am confident that, you know, she will take care of the children. And another person, the wife may well say that she's very confident. And the risk is not so much while one of the parties alive. While one of the parties alive, we're hoping that they will do right by their kids. But you could well have a scenario play out where both pass away and the property moves to someone else. So where there are children involved, either a couple comes to me and they already have children, or maybe the woman has children from a previous union and now she's marrying a man, and you talk to her and she said, if anything would happen to me, I would want my child to get my interest. When you have that discussion, then it may be that a tenancy in common is the far better route than this constant telling married couples that they should do joint tenancies, joint tenancies. It may not work out at all. I can think of a case, for instance, Lestine, where a gentleman and a woman bought property together, and the lady predeceased the gentleman, and they had a child together, a daughter. And when she predeceased him, he remarried, moved to Canada, and then he died. And therefore, he didn't even leave a will. But again, if you don't leave a will and you have a spouse under the Intestate Estates Act, the spouse becomes the #1 person that will get the largest share of your estate. So she will get the real estate and most of the money. So even if it's a situation where it's not like her name is on the title, even if her name is not on the title, from the mere fact that she's your current spouse, when you die, that person, that second wife, would become automatically entitled to the real estate, and then your child that you had with your first wife would be left in the cold.
Yes.
So one should think very carefully before going along the route of joint tenancy.
So in closing, can you just recap some of the main points? You brought up a lot of examples here, which was very interesting. Can you just recap as we close the main points that you mentioned earlier?
Sure, Lestine. So while joint tenancy is a good tool that has been used for the ownership of properties over many centuries and will continue to be a good tool, one should be very careful in going that route. And all too often, persons go that route through ignorance. They're just told that they can acquire this real estate as joint tenants so that if one party dies, it moves to them, and they don't consider it anymore. What if both of us die? What if I die and the other party remarries? They don't consider that. If those are concerns, then joint tenancy may not be the best route. If you have a bank account, be careful, be very careful who you put on the bank account along with yourself, because if anything happens to you, said person will become entitled to the funds. Many parents may opt to do that and are quite happy with the possibility that if anything happens to them, then their child or their children will have access to the funds. And in fact, many spouses may be quite happy with that possibility too. But what you need to consider is whether the person that you're adding to your bank account, whether you're happy with the possibility, not just a possibility, but whether you're happy with the fact that if you die, they will become entitled to the funds. Remember that doing a will not change their entitlement. Likewise with real estate. If you own a house jointly with someone, doing a will to say that you're leaving your interest to your children will not sever the tenancy. It will still be a joint tenancy, and the children still will not be entitled in priority to that person who owns the property jointly with you. So the will have no impact in that regard. The will be null and void in that aspect. As I mentioned, will, a freebie to leave you with is that person should also know and be aware that marriage will invalidate your existing will. What that means is that if you own some properties and you had a will before you got married to someone, and in that will you had devised the real estate or bequeathed, which is the word we use for personal estate, bequeathed those properties to your children or your family members, please note, please be reminded that the minute that you become married, that will become invalid, null and void. So don't be thinking in your mind, oh, I did a will 5 years ago and that will I don't need to do it over. You need to do the will over if it is that you continue to want those persons that you had given the assets to 5 years ago in your will, because the marriage would have invalidated the will, and what would happen is that if you were to die, your estate would be regarded as being intestate. That is to say, no will was left, and therefore the spouse now would become entitled in priority to the real estate and to the bulk of the personal estate. So do over your will once you get married. It's to protect your loved ones.
Okay, thank you very much for sharing with us. As we close, just want to remind our viewers that they can advertise with us. Check the description below for the details. And thank you so much, Shena, for sharing with us today on joint ownership of property. You brought up a number of valid points, and we're grateful that you took the time out to share with us. Until next time, see you again.
Thank you, Lestine. All the best.
Again. Once again.